My client is a resident of Central Florida. She's a wife, she's a mom, she's a professional, and she has no criminal history. Yet she finds herself charged with battery after a parking lot incident. These criminal charges give us the opportunity to talk about a very narrow aspect of Florida stand your ground law that's still largely unsettled. What effect does stand your ground laws have on police investigations of self-defense claims? The police responded to a Signal 22 disturbance in the parking lot of a big box outlet store. My client was one of the two people involved, and they both said the same thing. She did it. Luckily, there was an independent witness that saw the whole thing. By independent, I mean they don't know either of the parties involved. They have no vested interest in the case. That independent witness said that my client got hit first. My client was the victim. Not to be overly dramatic, but there's also racial undertones that can be heard on the police officer's body camera by the other party. The police didn't believe my client. The police didn't believe the independent witness. They brought charges against my client. Now she's had to come out of pocket to defend her name. Unbelievable. If you're already familiar with Florida stand your ground laws, you might be asking yourself, how could they make this charge given subsection 2 of the stand your ground statute? If you're not familiar with Florida stand your ground laws, don't worry. We're going to get you up to speed with the basics. That way you'll be prepared to dive deeper into the law. And that's exactly what we're going to do in this video. Intro stand your ground starts now. In 2005, the state of Florida passed its stand your ground law, becoming the first stand your ground law in the nation. There was a lot of questions of substance and procedure with how the law worked. This is all brought to light in 2012 with the most unfortunate of incidents. February 6, 2012, Trayvon Martin was shot and killed by George Zimmerman. George Zimmerman was arrested and then later released under the stand your ground statute. The lack of clarity in the law fueled the turbulence in the street. Legal experts on the different media outlets couldn't agree with the law because it was ambiguous. There was no final instructions. In the past several years, we've seen the courts stabilize their positions with regards to stand your ground laws. This is good. It allows for fair and consistent rulings. It's really formulaic. When I say formulaic, I mean there's 3 steps to the process. Step 1 is the defendant must present a claim of self-defense that meets a prima facie showing, meaning the court's going to take whatever you say at face value. If you can do that, you move on to step 2. That requires the state to overcome your immunity to protection with clear and convincing evidence. That's a difficult burden to meet. Put a definition of clear and convincing down in the description. Step 3 is the judge's ruling. After hearing all of the presented evidence, the judge is going to make a determination on who prevailed. If the judge sides with the state of Florida, the charges will continue forward and you'll be taking the active steps towards a jury trial. You'll also be negotiating for a plea at that point in time or fighting it with additional measures. If the judge sides with you or the defendant, at that point in time, you are immune from criminal prosecution and the state is required to drop the charges. That immunity also carries over as a civil protection, which means if they try to sue you for the injuries that you caused, almost certainly they're going to lose. And when they lose, they're going to have to pay attorney's fees on top of that. Now that you're up to speed on the basics of stand your ground, let's zoom in and look at one narrow, still unsettled aspect. What limitations does stand your ground place on police investigations? And how does it affect the outcome of your case? That's what we're talking about. So turn to Florida Stand Your Ground Law 776.032. We're going to focus in on subsection 2 and read the instructions the legislature gave to the police. Let's look at the language. A law enforcement agency may use standard procedures for investigating the use or threatened use of force as described in subsection 1. But the agency may not arrest the person for using or threatening to use force unless it determines that there is probable cause that the force that was used or threatened was unlawful. At first glance, it appears that this subsection provides people claiming self-defense with widespread protections. That's not the case. To introduce part of this problem, I want to play for you a small segment of a stand your ground training that I recently attended by 2 awesome attorneys.
It says you protect against arrest. How do you protect against arrest? What about rearrest? What happened in my case was the state no-prossed it with the intent to refile. And my belief is that if you're protected against arrest, you should be protected against rearrest. But part of the problem is, can you take action when there's no case? that there is case law stating that once the state no process, you can't take any further action in the case. So what do I file? And I still tried to file something in it where it's being decided, but I mean, the law says it protects against arrest, but doesn't provide a vehicle.
His assessment, in part, is attacking the language of the statute that provides protections against arrest and pretrial detention, but doesn't provide a procedural mechanism for which that can be carried out. That's where I want to get into here. Let's break down that subsection of the law into bite-sized parts so we can get a better understanding of what's actually being protected. As we start, we run into two significant legal words that have to be defined: probable cause and force. For probable cause, let's look at the Police Academy definition. Probable cause is based upon the totality of circumstances and is the fair probability or reasonable grounds to believe that a crime has been or is being committed. Force. For our purposes, we're going to define force as it relates to a battery. The offense of battery occurs when a person actually and intentionally touches or strikes another person against the will of the other. Okay, so what does all this mean? Step one, is there probable cause to believe that a battery did occur? In our fact pattern, both parties said the other party started it. It's not in question that a battery took place. Step two, is there probable cause to believe that the amount of force used was unlawful? This is a little bit more complicated and requires a deeper or further analysis of probable cause. To understand the thresholds of probable cause, we got to have a better working definition than what was just offered in the Police Academy book. Probable cause is formed when the facts and circumstances would lead a reasonably prudent police officer to believe that a person did commit the offense. The best way to understand the lowest threshold of probable cause is to look to the lowest threshold probable cause arrest. You know what you'll find? Domestic violence. Every police department that I've ever interacted with has had a pro-domestic violence arrest policy, meaning if there's probable cause to believe that an act of domestic violence took place, you must arrest the person. If you let a domestic violence suspect go, that could be grounds for termination. Because of this, we see the thresholds of domestic violence cases for probable cause to be very low. It's pretty clear. A handwritten statement by a spouse saying, "He hit me in the chest with his fist," that's enough. That's going to put you in jail. To arrest you, they've got to have probable cause. That statement is good enough. How is that different from our circumstance here? We have a lady writing a statement saying she hit me first. You know what's different? In our situation, we have an independent witness. That independent witness said, no. This girl's right. The officers didn't look at that or discounted that. If probable cause can be established by a person writing a statement saying, "He hit me," the only way this law really helps you is if there's no witnesses left. You know what I'm saying? In our parking lot case, the officers were reasonable and didn't make a physical arrest. Instead, they filed with the state attorney's office. Keep in mind, in a stand your ground hearing, this is exactly opposite. All the situations we've talked about today was a threshold the police officers had to meet in order to put you in jail. But at the stand your ground hearing, everything's flipped on its head, because all you have to do is lay out your single claim of self-defense, and then the state has to overcome that. This is all the more reason for you to not talk to the police during an investigation. They didn't arrest my client, but they certainly didn't do her any favors. She wrote a statement about the events, and then they used what she wrote in her statement against her in her charges. Are you the type of guy that would defend your family if they were attacked? Have you ever practiced what you'd say to the police officers in the aftermath of a self-defense situation? This is a critical stage in the investigation. As friendly as they may seem, they're not on your side. It's not your job to explain the situation to them. People don't train enough for self-defense situations. Even when they do train, they train for the tactical side. What have you done to prepare yourself for the aftermath? Here's a training takeaway that you don't have to be at the range to practice. I'm happy to speak with you, officer. I just need to speak with my attorney first. If you want to learn how to refuse police advances and police requests for searches politely, check out this video. I've included a link to the references that I've made in the video down in the description. Whether you're a native Floridian, new to Florida, or just visiting the Sunshine State, on this channel, we aim to educate men of good character to be competent in Florida law. Hit it hard.